So thank you very much. This will now turn to the third panel, which will focus rather than on the form, more on the substance of a potential peace agreement between Russia and Ukraine. And this panel, in contrast to tomorrow's panel, will look at the question of territory, which has come up as probably the central question under dispute here. And we have three experts who will talk with us. I will introduce them as they start their remarks. Just as you see on the panel, we have about an hour for the presentations, and then we have the opportunity to go for another coffee break. But if we have the feeling we want to continue in the debate, we can also stand here and then go for the reception a bit earlier after this. So without further ado, I'd like to introduce Professor Marc Weller, who's a professor of international law at Cambridge University, and he is also involved with the Cambridge Project on Settlement of Disputes and has been working and thinking about peaceful settlements for the Russian aggression against Ukraine for quite some time now. So please welcome Professor Weller.
Thank you very much. We should add that I also work for Chatham House in London. I am so grateful to have been invited here because it gives an opportunity to be pulled back from the Straits of Hormuz, from Venezuela, who should be its president, or what we can do to innocent fishery vessels near the coasts of Venezuela when they look suspicious to us, to come back to what in fact ought to be the major issue of our time, which is how to address the dramatic Ukrainian crisis. So I know that you planned this conference before Iran and other little upsets occurred, but it is really excellent that we keep focus on this important episode. My presentation is trying to apply some of the things we've been discussing already to the various emanations of peace proposals that have been discussed by the parties. I'll briefly list some background facts and the international legal framework I think we have adequately covered. So I just mention one or 2 points just as a reminder. And then mainly we'll focus on the elements of negotiations. And because I know what a strict and rough timekeeper you are, I've given you a handout which summarizes many of the background points so that we don't need to spend too much time going through them. And the second page of the handout is a grid that summarizes most of the positions that were advanced by the parties. And I'll be using that and refer to it. It wasn't quite wide enough page that it could get everything in it. In particular, some additional elements of the latest Ukrainian position in the 20 points. But let me start with the background, just mentioning one or two key elements of what's on the page in front of you. It's difficult to discuss this issue without remembering what it means for the Ukrainians. They have a very strong sense that this is not a use of force that aims to acquire territory. This, from their perspective, is a use of force that aims to extinguish Ukraine as a state and nation. The Ukrainians are the second largest ethnic community in the Russian Federation. They point to the fact that they argue that their rights there are repressed, extinguished, and you have seen Mr. Putin's lengthy justification for the war, where he argues that Ukraine is a kind of historical mistake. It shouldn't have happened. It was Lenin who thought of it. What can you expect? Therefore, the Ukrainians, I think, take the view that even if we had a ceasefire or some sort of arrangement, it would be temporary, that Russia would be back to finish the job. That may or may not be true, but it's just useful to bear in mind when we think about some of the proposals that are being made. And of course, it has an immediate impact on some of the demands made by the Ukrainians, especially on security guarantees, which I think inform their position. So there's a kind of expectation that a settlement may just be a break in hostilities, but may not entirely be the end of it unless there's a very, very persuasive security guarantee. On the side of the Russian Federation, again, the piece of paper you have in front of you lists some of the there were almost emotional justifications and rationales. The issue of pushing back NATO. But now that territory has been captured, one of the essential aims, of course, is to have a formal ratification of this fact. And that's in a way what we have just been discussing. As you know, the Russian Federation is demanding not just that Ukraine signs an agreement in which it gives away its territory, but that the rest of the world recognizes this as lawful. And we go through some of the iterations of the various agreements where the Russians put forward these positions. On the legal environment, well, the truth is that this is an instant where virtually every last one, with the exception of slavery maybe, of the jus cogens obligations that we know about have been significantly violated. Prohibition of the use of force, armed intervention, grave breaches of the Geneva Law, ethnic cleansing, sort of all of the issues, basic human rights like torture, all of the jus cogens type obligations, I think, virtually all of them are violated. And that, of course, should trigger automatic consequences. Obligation of non-recognition, and it's not that you need a Security Council. These things should just happen automatically. Obligations imposed upon the rest of the world due to the fact that someone else violated these jus cogens principles. Non-recognition, non-assistance in maintaining in place the violation, and to cooperate through international institutions to oppose the consequences of the violation, to reverse it. And then we have this odd fact that avenues of negotiations have been opened, which we would probably not have expected, mainly by the US. Avenues that appear inconsistent with these legal requirements, where I think the Europeans have taken on a particular role to try and somehow defend the international legal system and the Ukrainians. And that relates to the next page of your handout. What are the main phases of the negotiation? And I apologize to rush through. I'm trying to keep the little bit of time we have for the substance of the actual proposal so that we can compare them to the international legal system. The first phase is very unusual. It's bilateral. The Ukrainians sit down with the aggressor in Belarus and have direct meetings just with them. Oddly enough, they come up with an agreement. Initially, the Istanbul Declaration, which is very short, 1.5-page document of principles, but then there are various iterations of a full peace agreement, which sort of until the middle of April was developed, and where the square brackets in it over time tend to disappear. It's interesting to look at. We'll do that a little later. And then we have a hiatus when this agreement is not pursued. The Russians withdraw from Western Ukraine, and we discover the horrible butchery at Bucha and other places, the grave violations of humanitarian law, massacre of civilians, which destroy any prospect of discussions on peace agreements for several years. During that interim phase, we discuss grain, maybe exchanges of POWs, but there is no market for discussion on a peace agreement. Also from the Ukrainian side, there are attempts by others, India, Brazil, group of African states put forward peace plans. There are conferences where the idea is we bring most states together in places like Copenhagen and 3 others, where the world will refer to standards, and those should inform how a settlement should be generated. So kind of Harvard negotiation proposal approach where we say, look at international standards, and that will help generate the solution. But of course, Russia is not particularly interested. And the problem remains that both sides do not want to settle because both sides think that they can still win the conflict. And that is why the massacre at the Oval Office a little over a year ago, well, a negotiation person could probably explain it as a necessary step to persuade the Ukrainians that now they have to seriously engage in negotiation. however brutal and unsavory, it has that effect. Mr. Zelensky emerges shaken from the Oval Office. He's given tea by King Charles, so that helps to restore confidence. But then the Europeans sort of take their role. UK, France, and Germany, and actually assist the Ukrainians in gaining some sort of position vis-a-vis the US and not just the Russians. But we have then the domination initially of the US position. The US offers 8 points, final non-negotiable points, to the parties, which actually are not entirely foolish points, except that there is an element on recognition of territorial change, where the US offers formally to recognize, in particular, the incorporation of Crimea de jure, which is, of course, unusual. The two parties exchanged position papers in the summer of last year, June, and these are the first time that they formally exchange what they think the positions are, and they are just as incompatible as they were in 2022. So the fact that they're now meant directly to negotiate on their position brings them back to the very sort of extreme of either side's positions to offer discussions. And then we have the fourth episode, which is the US-European sort of recent push since November, when we have Witkoff's 28-point plan, which is immediately answered by a European version of that plan that defends it and takes out the most un-international lawful, as it were, elements of it. And then finally, we have present status, more or less, which is Zelensky's 20-point plan that takes elements and language from these efforts, but it's mainly in accordance, obviously, with the Ukrainian and the European position. We had some inconclusive meetings since then at Abu Dhabi and Geneva, but then we have the Iran crisis overshadowing everything. Not much more going on. In the meantime, the Europeans, the coalition have been willing for a year or so, have started to prepare for the implementation of a security guarantee. There are some thoughts at the bottom of the page on the odd structure of the negotiations as they have developed, in particular a committed US mediator, but not committed, as you would have thought, towards Ukraine and international legal principles, but apparently committed to the other side, rather than the position of the NATO allies, the position of Russia, arguing, perhaps with some justification, that having armed Ukraine and sustained it for many years, therefore they now have to go the other way and show that they are balanced. But in reality, it's a somewhat different position, and a position that makes it quite difficult to gauge what the chances of a settlement are, because there are these persistent rumors that at the Anchorage summit, Mr. Trump and Mr. Putin agreed elements of a settlement which are, to us, perhaps difficult to accept. And occasionally Mr. Lavrov and others are pointing to the fact that they think whatever you're discussing, whatever 28 or 24 or 20 points you have in the end, the shape of the settlement will be what President Trump promised us. And we don't quite know to what extent he did and what that promise entails, but it seems to entail certain territorial concessions. So let us now look at the grid and just sort of compare what we have throughout the various positions and how that relates to international law. We noted sovereignty, non-intervention, free choice of political system. These are all 26, 25 friendly relations, core principles of international law, the Nicaragua case. We have the inherent right of self-defense, which Nicaragua and the Nuclear Weapons Advisory opinions tells us your preparations for defense by arming yourself are part of your sovereign rights. We have international law that tells us that neutrality is in fact a legal obligation an obligation to be able effectively to defend your territory so that no third states can profit from violating your neutrality and taking it over. And of course, territorial integrity. All morning we've been discussing the prohibition of the forcible acquisition of territory. And that means that there cannot be recognition of an outcome that changes the status of territory through the use of force. Now, starting with the status of Ukraine, the initial agreement of the sides, or virtual almost agreement, following the Istanbul Declaration in its version of the 15th of April, this is a situation when Moscow is still has its forces also very much around Kyiv in western Ukraine. They withdrew these forces after a 15-page also draft peace agreement is almost agreed, and perhaps the expectation that this would be the final agreement, but there were then circumstances that changed, including advice from Western states on some of the issues there. Ukraine promised permanent neutrality, and the initial design was one which is reminiscent of the 1839 sort of London Conference and Belgium being internationally declared neutral, i.e. that you have permanent neutrality enshrined in a kind of collective settlement, where neutrality is not just promised by Ukraine, but maybe that all the guarantor states to the agreement have a kind of legal right to enforce it, which of course is something which the Russians might be thinking about, given that two key states have recently just abolished their neutrality, which you wouldn't have thought they could so easily do. In particular, since there was a sense that perhaps in relation to one of them at least, it was maybe supposedly permanent neutrality. The final US points do not deal with neutrality, but only with NATO, which I'll come in a moment. The UK position, the Ukrainian position, claims that Ukraine should not be forced to be neutral, which doesn't exclude neutrality. The Russians obviously demand neutrality. The US, European, and Ukrainian 28, 24, 20 points all just confirm the sovereignty of Ukraine. So they no longer offer neutrality, but instead address the issue of whether Ukraine can be a member of NATO, which is a different thing. Neutrality is a much more comprehensive legal regime that has many other legal consequences that go significantly beyond the question, can Ukraine be a member of NATO? On NATO, there are different formulations, but most of them exclude NATO. The initial near draft agreement says no alliances, of which Ukraine can be a party. The final US points say that Ukraine will not seek to join NATO, which is a kind of political aim in a way. It's fairly weak. Ukraine doesn't say, I am already virtually a member of NATO, go away. It says it depends on the consensus of the alliance, knowing full well that at least at the time before the Hungarian elections, there would not have been a consensus in the alliance of admitting it. But, the future might be different. It doesn't exclude membership. The Russian position very clearly says no alliance, and first here. Then we have the US 28 points. As you know, they're a little bit amateurish and odd and unusual. Here we have Ukraine will not join NATO, which should be put into the Ukrainian constitution. At the moment, the Ukrainian constitution, as you know, has the ambition of joining NATO expressly included in it. That is to be changed. But then also it says the NATO statute. I thought it was called the Treaty of Washington or some such, but it's the NATO statute that is to be changed to exclude specifically a possible member state, Ukraine, which is, of course, fairyland and very strange. As you know, NATO's position is that, we evaluate any candidate that comes, but we don't exclude that a particular candidate can come. And then there's again, the Europeans trying to balance it out and making it acceptable. Joining NATO depends on consensus in NATO, and then they had to reassure the Russians, which does not exist. But of course, that might change over time. Because the EU, they all agree that, and that's quite interesting, that the Russians agree in all of the versions that we have that Ukraine can be a party to the EU. Initially, in one of the earlier drafts of the April draft agreement, they said, but not the common foreign security policy. But that's dropped. Personnel, I mentioned earlier that normally it is part of the sovereign rights of states to arm themselves as they see necessary for the defense. Very significant restrictions. And there's a long annex to the April draft agreement of 2022, which excluded lights, how many tanks and other things Ukraine is allowed to have. A limited number of military personnel. And we've come back to that. 600 proposed in Mr. Witkoff's 28 points. Now the idea is 800,000. I think at the moment there are between 1 billion and 1.2 million Ukrainian soldiers. And the general guess is that this is way above the peacetime level of Ukrainian forces. Both 600,000 and 800,000 would have been acceptable. But now the proposal is 800,000. No foreign forces, alliances, or presences on NATO on Ukrainian territory. All of the provisions say that throughout all of the agreements, except, of course, that recently we have added the European element of the security guarantee, which, after all, would be European forces of some NATO members on Ukrainian territory, although not under NATO command. And presumably that's how some of the more recent EU endorsed or European states endorsed provisions can say no permanent NATO presence. By the way, in the box before, I made a mistake. It should say no NATO forces in Ukraine and jet fighters in Poland. So there will be NATO jets just next to Ukraine, but not in Ukraine. And that is repeated in the EU position, adopted from the 28 points. Presumably that's the sort of US acceptance, the idea that there can be a potential clearing of the skies. Significant restrictions on weapons, we'll leave that out because we don't have time. The big change that occurred, of course, through the negotiations. In the beginning, the US insisted on ceasefire first. And that changed like this in August in Anchorage, when they accepted that the ceasefire would only need to take place once the political settlement essentially had been agreed, the full settlement. And normally you would have a ceasefire as a means of achieving the settlement to generate debates, break in the fighting. There was the compromise proposal, which was a 30-day ceasefire to try and achieve a settlement during that period. But Anchorage reversed that, which is unusual, without really any explanation other than that was the Russian position, who I think wanted to fulfill their military aims until, and continue doing so until they had achieved the political demands that they had. Forced withdrawals, this in the initial agreement under the Istanbul Initiative of 2022 was a bit uneven. Ukraine would withdraw all its forces back to bases, and the withdrawal of the Russian forces would be discussed later, basically, once the agreement is fully ratified. On the other hand, Russia did withdraw anyway, most of its forces, all of its forces from Western Ukraine, perhaps in the expectation of this agreement, or also because militarily their presence wasn't viable in any event. There is a proposal that within 2 minutes I shall have to tell you about everything else. Territory, that in a way is the essence. Initially, in the draft agreement, had it been signed, obviously Ukraine would have done pretty well compared with where they're now. It would have been Donbass more or less as it was on the 23rd of February 2022. There would have been a standstill in relation to Crimea, where Ukraine would have agreed not to challenge forcibly that position and have negotiations at some point on its final status. In the final US point, we have the introduction of the idea of de jure recognition by the US of the forcible incorporation of Crimea and de facto recognition of the other four provinces. In exchange, Ukraine would get a little bit of territory in Kharkiv. You mentioned in those days, President Trump was saying, talking about seafront property that the Ukrainians might get back, and some others. Now we have the idea that the Russians are demanding a withdrawal of the Ukrainians from their own territory, which they still hold in the Donbas region, and that is being addressed in the US proposal. Yes, the Ukrainians have to withdraw, but that part from which they withdraw will become a demilitarized zone. But of course, unless you have a pretty solid monitoring and peacekeeping mission there to ensure that Russia doesn't infiltrate its own armed forces into the demilitarized zone, that is very difficult. And in his latest 20 points, Mr. Zelensky has sort of no longer resisted that too much, except to argue that, yes, both sides have to withdraw their forces in that zone. So it's not just Ukraine going backwards, but also the Russians. And the zone remains under the jurisdiction of Ukraine. Under the Trump plan, the zone becomes part of the territory that de facto is recognized as Russian. And this could then become the economic area, which we'll hear more a bit later. I think many of the other things I would just have to leave out. Just to mention on security guarantees, there has been a very significant change, given that since more or less this time last year, the Europeans, through this coalition of the willing, have generated an expectation by the Ukrainians that there will be a NATO Article 5-like, so triggered by an armed attack, and the kind of sense that an attack on one is an attack on all, although not firm promise to respond in a particular way. And then there is the original Ukrainian formulation to close Ukrainian airspace, i.e. air defenses, where Ukraine provides weapons, use armed force. But I think at the discretion of the guarantor states. Also interesting, I think, the idea of snapback sanctions, which we know from the JCPOA, which would be, I think, a very good thing one could introduce in the Security Council resolution endorsing sanctions, endorsing a settlement. But generally speaking, of course, it's quite doubtful whether the Russians will accept any foreign military presence by major states from a territory of Ukraine, and whether the undertaking that the West is giving to Ukraine may actually be something that in the end cannot be delivered. And if it cannot be delivered, given the sense of the Ukrainians that they are facing the next conflict, even if this one concludes pretty soon, whether that might undermine their wish to come to settlement. There's one other little issue which we discussed during the break, which is the issue of the constitutional position in case there's a settlement, whether Ukraine can actually accept an agreement that alienates territory, to which the answer is no. The Ukrainian constitution has been changed to make it impossible to alienate any of its territory according to the constitution, and that part of the constitution cannot ever be changed. So only a revolution and a new constitution would change that fact. But of course, that just assists us in thinking that we have to rule out a formal acceptance of territorial change, although there could easily be a result where the facts on the ground are stabilized without taking a view as to who owns what territory. Thank you so much.
As you were closing out with territorial concerns, this ties very well into our next presentation by Professor Dr. Helmut Aust, who is a professor of international law at Freie University in Berlin, and will join us here at the Institute very shortly, was already with us here. And he has done research on many issues, but including on issues relating to the Russia-Ukraine war, including a series of blog posts on the grain deal. And that's why we are very happy for his presentation on special economic zones as an element of peacemaking.
Yes, thank you so much, Florian, Dr. Kriener, for the kind introduction and the invitation to be here. It's a great pleasure and honor to participate in this workshop.
Do we have slides? Sorry, do we have slides?
No, I don't have slides.
Okay.
It's a great pleasure to be here. I will talk now on something which is probably the most obscure topic of the workshop, as it is something which is not discussed very often and very openly, but which has come up in various stages of the negotiations. And this is an idea to create a so-called free economic zone as one piece of the puzzle for the territorially disputed questions. An earlier version of the program also put the title a special economic zone or a free economic zone as the solution to the territorial dispute. And then I first asked to add a question mark and then later asked to change the title entirely, as I do not think that this concept will be the solution for the territorial issue. It is also a bit unclear what we are talking about specifically, as this concept of the free economic zone gets sometimes mentioned, but it is never really entirely clear what this would entail. And so one could also ask whether it's premature to even give this topic attention here in this forum. I think it carries certain risks to discuss it and to become a bit speculative, but at the same time, I do see reasons which relate to other patterns of US peacemaking practices at the moment, which should alert us to some of the implications of such a concept. In my presentation, I would like to make a twofold argument. I would first, after kind of explaining a bit more what a free economic zone could mean, what it could look like, I would like to discuss briefly whether it's in general permissible and feasible under international law. And then in the second step, I would argue that there are good reasons to be hesitant and skeptical with respect to this concept, which has to do both with kind of historical analogies, which caution us to be careful when it comes to internationalizing certain parts of the territory, but also then, as already hinted at, the kind of current trajectories of US peacemaking, in which such a suggestion of a free economic zone is embedded. And here I'm referring to the US-Ukraine Strategic Minerals Partnership, which is already in existence, which I think has some connections to these suggestions of a free economic zone, but also to other elements of peacemaking, such as the Gaza Trump peace plan, which has also been endorsed by the UN Security Council. Whatever the endorsement means, we have talked already a bit about this issue today following remarks by Sarah. Let me say a few words on how this idea of a free economic zone has entered the various discussions and negotiations. To me, it appears that the idea was first aired at around November, December 2025. And it was also then in this 20-point plan by Ukraine mentioned, which was, as we have just heard, a reaction to the 28-point plan by the United States, which was very pro-Russia, very Russia-friendly. And when talking about this 28-point plan, President Zelensky was quoted as having said that Ukraine would consider the free economic zone a potential option for a sovereign state to choose such a path. And then this idea of the free economic zone also appears in the 20-point plan in point 14a, even though it's not fleshed out in greater detail there. And was then apparently also, from what one can gather from publicly available sources, further discussed at the talks in Geneva in February 2026. But there, press reports indicate that at this meeting, the whole concept met with limited support by both Russia and Ukraine. And so it is, as mentioned, really very unclear what practical chances of realization this concept has. From what we know, the core idea would be to create a zone in the Ukrainian-held portion of the Donbas in eastern Ukraine, in which neither troops from Ukraine nor troops from Russia would be present. And such a free economic zone and also represent a kind of a buffer zone between Ukrainian territory and the area of Ukraine, also still Ukrainian territory, of course, controlled by Russia. This is kind of the general idea of what we know about these plans. And then the question is what it could entail in practice. And to me, this concept of a free economic zone evokes 2 points of comparison. One point of comparison is the concept of special economic zones, which is an instrument which is fairly well entrenched in international economic law. Even though also there we do not have one fixed concept of what a special economic zone means, but it's something which can be found in a great variety of different settings. But with this designation as a free economic zone, I think the whole concept also evokes reminiscences of earlier attempts of internationalization of territory, experiments that we had in particular in the League of Nations era, like the Nemo territory or the Free City of Danzig, for instance. But let us first look at the concept of special economic zones, as I think this is somewhat the nucleus of this idea to suggest a free economic zone. Special economic zones, as mentioned, is quite well known in international economic law, and they are commonly understood to be geographically delimited areas within a given state, offering certain incentives to businesses, which then would physically locate within the zone. They are typically spatially distinguished from the rest of the territory of a given state. And quite often they are characterized by a significant amount of deregulation. A special legal framework is created for them. They are supposed to create clusters with specific industrial and economic competences, sometimes also serve as laboratories for new forms of governance, and often involve deregulation when compared with the rest of the national territory, and are therefore kind of a tool to attract foreign investment. And all these factors, they play a role when setting up a free economic zone in parts of the Donbass. But one question one could ask whether the concept is really fitting for the broader geopolitical system, the situation in which we operate. So in one article on special economic zones, Douglas Tseng has put it, I think very nicely. He said, special economic zones are supposed to complement market forces by helping overcome market failures. And market failures can mean different things, but it's a concept which is very inappropriate when we look at the geopolitical situation that we have at hand. But still, this description as a free economic zone kind of sends the signal that this is about creating economic opportunities, and if such a free economic zone will then boost reconstruction and development in the area. There are a certain number of questions which one could then entertain. So would it be permissible to construct such a free economic / special economic zone? This is a question which could be addressed under international law, but also under Ukrainian law. I'm not in a position to comment on the domestic Ukrainian legal framework, but I note that there's a border law from the 1990s, which creates for the possibility to also create special economic zones in Ukraine, but I'm not going to go into the details here. Under international law, there's as such no rule which speaks against the construction or the erection of such zones, as long as other relevant obligations under international law are respected. When it comes to the question of how to provide for such special / free economic zone, one could have several follow-up questions, which also then connect this issue back to the broader questions which we have discussed. So we've heard in the morning, for instance, that also a formal peace agreement, for instance, does not need necessarily to be a legally binding agreement. And if one then thinks about the construction or the creation of such a free economic zone, there probably one would need some kind of legal bindingness if such a zone would be in a position to live up to the expectations with respect to economic development, as though investor would probably move to a special economic zone if this zone is not created on the basis of a legally binding framework. So probably this would require some kind of legal grounding, which, as mentioned, could be international law, but also domestic law, and further issues to be considered also in the light of broader analysis of special economic zones and international law. Issues like the time factor, we were encouraged to also reflect on this short-term versus long-term perspective. So in the literature, one typically finds assessments that special economic zones take approximately 10 years to work, if they work at all, which is controversial what they do. But even if one kind of buys their premises, one needs time. And if this is supposed to be a contribution to a settlement of the political and territorial dispute, the question is of what would really be gained by having recourse to such an instrument. Let me move to the second prong, the internationalization analogy. And this, as mentioned, in my view, follows from this description of a free economic zone. This does not necessarily mean that this zone would need to be internationalized in any given sense. One could also imagine it to be created solely under Ukrainian law, but still these connotations are there. If we talk about internationalization of territory, this is again something which is not a fixed concept in international law. This is a recurrent theme that we have today. We have basically no concepts which are fixed concepts in international law. Everything is always very contingent, but it also applies to internationalization. If we think about the free economic zone as an internationalized part of the territory, one could, of course, theoretically consider the UN Security Council and the United Nations as a body which would provide for this internationalization. And then we would have precedents from UN practice like international territorial administration, on which one could draw. But I think, as Gregory Fox said, this is not the world we are in at the moment. So this is probably not the most likely scenario that we have UN driven and UN controlled form of internationalization of such a zone. And then, if this is not available, we can look at other past practices of internationalization. And there, I would say, they are all very different in terms of the context in which they were created, but they kind of share the situation that their track record is considered to be less than positive. We have failed attempts after the Second World War with concepts, with attempts to internationalize Trieste and Jerusalem. We have the practice from the League of Nations era, where we had different examples like the Nemo territory, which also was not strictly internationalized as it was integrated into Lithuanian territory and sovereignty, but we also had the Free City of Danzig, which was internationalized. And these institutional models worked to a certain extent for a certain time, but even though they were considered to be permanent, of course, obviously, as we know, they weren't. And one particular reason why I do think that they are also not positive examples of practice on which to draw is that they stemmed from a broader puzzle, a broader attempt of territorial and indeed world ordering, which took place after the end of the First World War, and that maybe this is not a set of practices to which we want to return now in the given situation in which we are in. One can go back even further in time and think about the free zone of Tangiers and the international settlement of Shanghai as other examples where territory has been internationalized, but also these examples are highly problematic and controversial. James Crawford, in this The Creation of States, has described them as an extension and institutionalization of the system of capitulations, and has then written that for this reason we do not have present-day analogies in international law, and that they are not really useful as points of reference for the debate. I would fully agree, but the disconcerting aspect now is that I think we are no longer as sure as James Crawford was in 2006 that we will not have present-day analogies. So writing in 2006, James Crawford was in a position to make that statement in a very convincing way. This dates back to an era of international law which was completely different, and we cannot transfer these models to the present. But if we look at these current aspects of US peacemaking practice, we may actually be in a situation where we have some kind of like old ghosts revisiting us, haunting us now, and bringing back elements which we thought would have been overcome by now. And I think this can be illustrated with two examples. The one is the US-Ukraine Strategic Minerals Partnership, which is not quite easy to describe in a couple of seconds. It's a very complex setup. It has an international agreement, the United States Ukraine Reconstruction and Investment Fund, with the also not very handy abbreviation of UURIF. And in addition to this international agreement, which was also ratified in the Ukrainian parliament, in the US it's considered to be a sole executive agreement, if I'm not mistaken. In addition to this international law element, we have a limited partnership agreement under Delaware law, which also has not been disclosed, but which supposedly, as far as one knows from an earlier leaked version, is generally quite favorable to the United States with respect to various aspects of the exploration, extraction, and exploitation of minerals and related infrastructure in Ukraine. Now, how does this hang together with the question of a free economic zone and the broader questions we are discussing? I think, first of all, there's a factual connection, as if we're thinking about the free economic zone and what it's supposed to do in this area, there's a situation that many of the minerals which are covered by this deal are actually in the area which would also be part of this free economic zone, and in addition also in areas which are currently controlled by Russia. And legally speaking, this also raises the question of how the international law agreement, this UURIF, would hang together with a peace agreement. One could say if it's just a bilateral peace agreement between Ukraine and Russia, it's just a question for Ukraine to decide how to ensure that its international legal obligations do not contradict. But one could also think about bringing in the United States into such an agreement, and then to ask the question, how do these different agreements hang together? But beyond these doctrinal points, and this is something that also Greg Scheffer and Sergio Puig just mentioned in a great article in the American Journal of International Law, this minerals partnership is an example of a transactional turn in peace diplomacy, and they have very unkind words for that, which I'm not going to quote in detail now. But in general, this is shared by many other commentators. So Theodore Hanna at Opinion Jurors wrote of the preemptive carve-up of Ukrainian territory, and Mikhailo Soldatenko at Lawfare described it as an unequal treaty. And then we are back at the situation which James Crawford described as inconceivable in 2006, and we see that the context has just shifted radically. Second example to explain this point further is then the peace plan agreement endorsed by the Security Council on Gaza, which, as we have already heard today, concerns Resolution 2803, which has endorsed the 20-point peace plan by Donald Trump. And there, in these 20 points, we have language which speaks of a Trump economic development plan for Gaza. And in paragraph 11 also then mentions that a special economic zone will be established with preferred tariff and access rates to be negotiated with participating countries. And this ties in, continuing on the theme of seafront property, of these crazy ideas of a Riviera on the Gaza. But one can ask the question whether there's kind of a pattern that US peacemaking is now so much driven by this economic business focus that special economic zones and preferable conditions for real estate development and other forms of business activities are part of these solutions. And the most worrying point in this regard, most troubling implication, I would say, is the big question which is hovering both over Security Council Resolution 2803, but also the Ukraine situation. What is the continuing role of self-determination? And we discussed that earlier when with respect to the question of what does it actually mean when the Security Council endorsed something. It does not necessarily become laws. I would also say we don't have the situation that the Trump peace plan for Gaza is now international law in its entirety, but at least we have a resolution which also authorizes states and the Board of Peace to do certain things and to thereby disregard the question of self-determination in quite a brutal way. When one looks at also other aspects of Security Council practice in recent months, I have the impression that there are sometimes quite unexpected things going on. We have resolutions on Western Sahara, which is also relevant in this context. We have the 2817 resolution on Iran's attacks. What I keep asking myself is like, what is the background deal in all these situations that Russia has accepted these resolutions? And this is now very speculative, but I think the question of self-determination is the one should be concerned about here. So to wrap up, I'm coming to the end of my 20 minutes. I think as such, from a kind of doctrinal positivist international law perspective, there are no reasons as such why the creation of a free economic zone would be not permissible under international law, but it's certainly ridden with a lot of difficulties to have it implemented in a meaningful way. But there are, I would say, good reasons for skepticism, which derive from the historical analogies we have for internationalizing territory, evoking all these reminiscences of past practices, which we thought we would have overcome, and the current aspects of US peacemaking, which are highly transactional and business oriented. Final question I asked myself, is this all too negative? I think we were asked to be constructive, creative, or forward-looking, and I feel that I have miserably failed to be forward-looking. And I kept thinking throughout the day, like, what can I say in a positive way? And of course, one thing that always comes to mind is like, are we looking for the ideal solution or just second best options? And of course, there could be many scenarios which would be far worse than the creation of a free economic zone, but still, in the light of the points I've tried to elaborate, I would be hesitant to push for the creation of such a free economic zone. Thank you so much for your attention.
Thank you so much, Professor Aust, for this perspective. And now we turn to Professor Roman Petrov, who is a professor at the National University of Kyiv-Mohyla Academy in Kyiv. We are very thankful that you were able to travel here and talk to us. And Professor Petrov is very well known to us. He was a visiting researcher for quite some time after the start of the Russian aggression, and we've learned a lot from you before. And we're very excited and interested in your perspective on the Ukrainian constitutional perspective of these peace agreements. Thank you so much.
Thank you very much, Florian. Thank you for inviting me here. It's a great pleasure. I would like to warn that I'm primarily an EU lawyer, and but nevertheless, I will do my best. And there are my colleagues from Ukraine. If I'm mistaken, who can always correct me. I also would like to thank Helmut for his interesting presentation on free economic zones, because as a student, law student at Donetsk Law School, I've been particularly studying this issue. It was very popular issue at that time in 90s, and there was a vision, belief that this issue of free economic zones would elevate economic might of Donbass, but under Ukrainian sovereignty. And then, when it was already occupied by Russia, I checked websites, and they again came to the idea of free economic zones under sovereignty of Russia, with a belief to become, as I quote, second Singapore tiger. Yeah, so it's certainly the issue is very popular there, but of course the territorial affiliation is very important, because I guess both sides, either Ukraine or Russia, mean that it's going to be under their sovereignty. And another dimension is also the issue of whether, if it's under the Ukrainian sovereignty, it would comply with the prospective EU membership of Ukraine, especially with the EU common market, customs market, customs union. So it's another dimension to discuss. Yes, thank you, Mark, for your brilliant outline for this piece. options which are now on the table. As a conclusion, I would like to join your opinion and to say that the peace plan coming from Putin and Lavrov is in a state of fluctuation. It has been changing and shrinking from 28 to 20 points, maybe even less, but the core is unchangeable, what we can see from the Russian side. Exactly, it's a territorial issue because as we know, the Russian army now occupies 20% of Russian territory, basically 4 administrative regions, Autonomous Republic of Crimea, Donetsk, Lugansk region, and part of Kherson and Zaporizhia in the south. But the worst of all, that the Russian Parliament State Duma formalized and included under the Russian jurisdiction the whole territories of all these 4 regions, even including those which have not been ever occupied by the Russian army. So basically, it complicates the whole issue. So from a legal point of view, when we talk about the future territorial changes, if they happen, it would require effort from both sides and change the constitution. But coming to the topic of my presentation, I would argue that any territorial changes which might come from a prospective peace deal, as we agreed here that it's first it's going to be kind of a political settlement which might lead later on to the peace treaty, but peace deal would not work in Ukraine if we look from perspective of national constitutional law. It would not work. It would, in order to make any changes, any compromises demanded by the Russian side, the Ukrainian side must either repeal and adopt new constitution, then change the government completely and the parliament to conduct elections, and or as a last resort to agree to unconditional surrender. I don't see any other legal options to meet a Russian core demands for the peace deal, and I will try now to explain why. As a recent traveler and observer from Ukraine, I must say that I can presume that the Russian government actually understands it, and the major effort put and priority put by the Russian side is actually to force and to push the Ukrainian population to actually abandon any resistance and to agree to potential peace terms which would accept either of the options which I just outlined. Indeed, the most difficult moment took place in this winter when it was very difficult to face dark and devastating ice or possible surrender when you stay in an apartment with a very low temperature, and your mayor, in our case, Mayor Klitschko, says that in few days you have no choice but to leave the city. Our key ally openly rejects any perspective of a military support, and our major key ally cannot adopt a decision to provide financial support because of resistance and special position of several EU member states. So it was very difficult, but suddenly the sun appeared, the glimmer of hope, and it's very important to underline how a glimmer of hope is connected to the sun comes and resistance returns. So let's cherish the sun. Always, it helps. So my presentation, what I prepared, will focus on 3 constitutional dilemmas, which Ukraine, let's imagine that a peace deal somehow is reached, and the Ukraine is not pushed, but even both pushed and accepts certain compromise, which would inevitably lead to the revision of its territorial integrity. And in order to go forward in case of Ukraine, we are going to face 3 immediate constitutional dilemmas, which, in my opinion, makes the whole enterprise impossible. Dilemma number one. Dilemma number one, it's martial law status. So since 2022, next day after the invasion of the Russian army, on February 24, 2022, the martial law was introduced by President Zelensky, which imposes severe restrictions on political and economic freedoms, human rights, expression of these rights and basic freedoms, as well as special regime for movement of all people who can be subjected to the law of mobilization, including myself, by the way, and there's a separate law of mobilization. The martial law works in a system where it must be, it's valid only just for 90 days, and every 90 days it must be readopted or prolonged by the Parliament of Ukraine, as well as the law on mobilization. So far, it has been done automatically. On the last few days before the expire of the term of this law, Parliament of Ukraine assembles and prolongs the martial law and law on mobilization. The next round of the decision is going to take place on May 4th, 2026. Before that, the law will be in place. I would argue that, and of course, the martial law is the key for any changes to be taken within the Ukrainian society. First, no elections can be conducted. So the Russian arguments that mandate of President Zelensky and the Parliament of Ukraine is long overdue. It's true. Parliamentary elections had to take place in 2025, if I'm not mistaken. So it's been long overdue. So it's been basically completely legally dependent on the existence of martial law, because Article 157 of the Constitution of Ukraine prohibits any changes, any amendments to the Constitution, any elections, because of the law on martial law and law of mobilization. But the major problem, it must be perfectly understood not only by the Ukrainian society, but also by the Western society, that let's say, if martial law is repealed and stopped on May the 4th, it would cause immediate danger to the security situation in Ukraine, because it would illegally imply opening the borders, Western borders of Ukraine. And as I provided you with official figures coming from the General Prosecution Office of Ukraine, as of September 2025, there are nearly 235,000 cases against Ukrainian soldiers who left their units without reason. Nearly 54,000 deserted from the front line, and only 29,000 voluntarily returned, and criminal persecution, because President Zelensky introduced this amnesty clause. If you return, there is no criminal persecution. Only 29,000 came back. So in case martial law is repealed, there's a great danger that the front will not sustain. And you must understand that some soldiers have been on the front line for years without seeing their families. Most of the families are left abroad. Many of them, 1 million in Germany, including, with their children. And of course, logically, since the law will be repealed, we can expect a significant flow of Ukrainian soldiers, because simply they are exhausted. And I don't see how, let's say, the German government will find legal ways to stop this process and to return them back. So the martial law, how brutal it could sound, it's a very important legal mean to keep stability on the front and to ensure discipline and to ensure that the front is in place. So we must. So my argument is that the martial law, of course, must be repealed before the election are due to be conducted. But before that, political decision or deal must be formalized, finalized, and there should be certain guarantees that if Ukraine opens its western borders, then there will be no way back and certain guarantees must be in place. So it's a very serious challenge, dilemma, to be faced not only by Ukraine, but also by our Western neighboring countries. Dilemma number 2, which is connected to dilemma number 1, it's the issue of the legality of any change and revision of the territorial status of Ukraine. There is one mean to do it. Well, actually 2, but major one. It's any change of territorial status of Ukraine must be decided by the all-nation referenda. So there can be no law decision of the parliament. It's all-nation referenda, especially when we're talking about losing certain territories. And there is a clause which resembles heavily Article 157 of the Constitution, which says, and I quote, you can see it on the slide, law on all national referenda prohibits to consider the issues of territorial sovereignty aimed at termination of independence of Ukraine, violation of state sovereignty, territorial unity of Ukraine, endangering national security of Ukraine, including inter-ethnic, racial, and religious hatred. So basically, I don't see any political power in Ukraine which would be eager and bold to put the issue of territory on the all-nation referenda, because provision itself prohibits any, it's doomed to be considered against this clause. The only way, in my opinion, is, and it's actually envisaged in the law on territorial all-national referenda, is to consider the issue and check the compatibility with the Constitution of Ukraine through the Constitutional Court. And it's provided the Constitutional Court plays a very important role and actually has the authority to check the compliance of the subject matter of the referenda with the Constitution of Ukraine. Still, I wonder how even the Constitutional Court may consider voluntary partition of the territory of Ukraine, complying with the provision which also exists in the Constitution and the law on all national referenda. So it's a challenge number 2. And dilemma number 3, it's related to the voting rights, what we are facing and which is going to be very difficult to solve. How Ukrainian citizens in Ukraine and abroad may exercise their voting rights at all national referenda. So, first of all, to remind, no referenda plebiscite is permitted during the martial law. But when, let's say, there is no martial law and it's actually the door to appoint and to set a date for the referenda is open, we must take into account first, at least 7-8 million of Ukrainians left their country after 2022. The Russian government, they checked recently, claims that 2,008,000 Ukrainians got settled in the Russian Federation since 2022. We cannot check, but it's official figure from the Russian government. Ukrainian government estimates that about 6 million Ukrainians, including 1.5 million children, stay on the occupied territories of Ukraine. So basically Donetsk, Lugansk, Kherson, Zaporizhia, occupied, and Crimea. Plus, it's also must be taken into account that majority, if not all, Ukrainian citizens who live on the occupied territories, they were either put into position to accept or even sometimes forced to join the Russian citizenship. They have both passports, at least Ukrainian, or most of them keep it as a very good mean to actually enjoy the European and Ukrainian jurisdiction, and Russian as a mean of necessity. So basically, it's another issue which probably not subject for today's talk. It's in case Ukraine joins the EU, how to this number of Ukrainian citizens can be integrated and become EU citizens, by the way. But it's a story for another talk. So in case of all national referenda, with such a dispersed Ukrainian population in different jurisdictions, including on the territory of the country aggressor, I don't see basically how fair and democratic all-nation referenda plus elections for the president of Ukrainian parliament, which must take place before the referendum, can take place. Simply because it would imply that Ukraine needs to ensure rights, and of course the Russian government would insist that these 2.8 million Ukrainians must have access to the election points organized on the territory of Russia and occupied territories, express their will, and their voice must be counted. And we basically can presume what kind of a choice and voice will be made. And of course, where the Ukrainian election committee could be allowed to enter territory and to also ensure rights of competing opinion at the referenda to be expressed. It's a big question. So from a legal and practical point of view, it would be very difficult to ensure, and either side, after the result of the referendum, would accuse each other of actually unfair result and violating rights of each other to explain their defeat. It's obvious. So unless this issue is solved, it would be very difficult to ensure the legitimization of the result of the referenda, as well as elections of a new president and a new parliament. Because what we already can see now in Ukraine, some work is going on to actually set up and promote certain politicians and parties who would actually advocate the Russian opinion aimed at almost unconditional surrender and admission of the terms promoted by Putin and Lavrov in their statements. So overall, in the best case scenario, I tried to calculate to see it for you just from a procedural point of view, how much it's going to take if, for example, we remember there is the next revision of the martial law on the 4th of May. So before that, it's unlikely to happen, of course, but let's say if we take this date and miraculously, because the Parliament of Ukraine abolished the martial law on the 4th of May, how much it's going to take to legitimize any decision. So repealing martial law and mobilization law 3 months from May, then elections of Ukrainian Parliament of Ukraine can take place as fastest. And there is already an agreement, by the way, between president office and the parliament that there is a transition which it doesn't comply with our laws on election procedure, but there is an agreement that in case of elections, it can take place within 6 months. Then organization of all Ukrainian referendum after the elections of president and parliament, 3 months, plus review of the compliance with the Constitutional Court of Ukraine, minimum 3 months. So in total, we have 1 year. It's the best case scenario, but it's doubtful because at any stage it can take longer. So in the end, I hope I managed to outline for your attention at least some dilemmas, some challenges faced not only by Ukraine but also by the European Union and its member states in case of need to quickly move and accept any peace deal, and generally without either abolition of the constitution, which set up all this frame, without admitting possibly defeat and basically accepting any terms from offered by the Russian Federation, it's impossible to legalize any succession of the territory. Thank you very much, and I'm open for the questions.